the author of 2 books. He's the author of 2 books, including Act of Justice, Lincoln's Emancipation Proclamation and Law of War. Lincoln's historic act will be the focus of today's presentation. Buzz, we thank you so much for being with us. We're a small group, but being able to attract somebody of your reputation and whatnot, we are most appreciative that you agreed to be with us. So big thanks to you and a thanks to Carolyn. So you're off and running.
Hey, thank you for those kind words, Gene. Actually, I retired from the State Department in 2017. Can't get the George Washington University website to update my biography for some reason, but so I'm a former member of the Swamp.
I don't know why.
Our previous president would say. Okay. Well,
We're back to the.
there we go. What I'm going to talk about is basically Abraham Lincoln's intellectual journey. Remember in March of 1861, where he's actually February of 1861, in his first inaugural address, he specifically said he was not going to interfere with slavery in the states where it actually existed. But then a little over a year and a half later, in September of 1862, he issues the initial preliminary Emancipation Proclamation. So intellectually, how did he get from here to there? How did he get from promising and sincerely not to interfere with slavery where it already existed to saying the federal government would regard as free all slaves under the control of the insurgent states? To understand that, you have to understand that there were the differing views on what the Civil War was. Now, it was the views in Washington, D.C. and in Richmond, Virginia were very, very different in 1861. The Confederate view was very clear. We are independent. We are a sovereign state and entitled to all the rights and privileges and international law of a sovereign state. And particularly in the event of a conflict, all the traditional laws and usages of war fully apply to us. It's often said that the Civil War wasn't a real war because it was never declared war. Well, that's not true. The Confederacy declared war in April of 1861. So they viewed this as an international armed conflict. The view in Washington was quite different. We all know of Lincoln's doctrine that the secession is impossible. The states cannot secede from the Union. There's no such thing as the Confederate States of America. What it was just really a vast criminal conspiracy, a treasonous conspiracy among insurgent individuals. There was no entity that the Union would recognize called the Confederate States. And there was concomitantly then a reluctance by Lincoln's government, a reluctance to do anything that would accord any legitimacy, any international status to the so-called Confederate States of America. And the few times Lincoln had to refer to the Confederacy, he would usually call it the so-called Confederate States of America. Among the things that you wouldn't want to do necessarily to give legitimacy to the Confederacy would be to treat its armies in accordance with the international laws of war. If you captured enemy soldiers, would they be prisoners of war? Well, that would give them an international status under international law. So there's a reluctance to do that. Now, as a practical matter, that theoretical construct quickly collapsed like a house of cards. It first came to a head as a result of the secession of West Virginia from the seceding state of Virginia. The western counties of Virginia, northwestern counties, were loyal to the Union. They had very few slaves there, and they did not agree with the decision of what they viewed as the Tidewater elite to secede from the Union. So they asked for assistance from the federal government to maintain their own independence. And for a time, they claimed to be the only lawful government of all of Virginia, because they said the rest of the place had committed treason and we're the only lawful ones. As it happened then, General George McClellan, later to be the famous or infamous commander of the Army of the Potomac, was originally commissioned as a major general in the forces of the state of Ohio. McClellan's forces then attempted in June and early July to invade Western Virginia to, in fact, liberate the western counties from what they thought of as tyranny of the government in Richmond. Before McClellan's forces, mainly Ohio soldiers, invaded, McClellan telegraphed to the commanding general of the army, Winfield Scott, saying, okay, now we're about to invade here. What do I do with people I captured? If I think somebody's a spy for Richmond, what do I do with them? If I capture enemy soldiers, what are they? Are they traitors to be turned over to the U.S. Marshal, or are they to be treated as prisoners of war? What about people who give aid and comfort to the Confederacy, even though they're not up in arms? What do I do with them? Well, in response, Washington did what the federal government has always been very, very good at doing. They dithered. He got no response whatsoever to his request for guidance. Okay, so the invasion starts. The Union forces are successful. Eventually, the state of West Virginia is admitted to the Union as a separate state. But in the meantime, on June 13th, on June 28th is when McClellan had asked for guidance from Washington and got a resounding silence in reply. June 13th, Lieutenant Colonel, Confederate Army, Pegram surrenders to McClellan's forces after the Battle of Philippi. I've learned it's Philippi, not Philippi. That's a picture of the bridge over a strategic river that was the focus of the, it's obviously been reconstructed, but it's the bridge that was the focus of the battle. Union artillery was on the hill in the background there. That's one reason that the Union won the battle. But after the battle, the Confederate commander, Lieutenant Colonel Pegram, surrendered about 500 of his men. He surrendered them on the assurance, and this is what McClellan, again, telegraphs to Washington. He said, okay, I have promised, quote, to treat them with the kindness due prisoners of war, but stating that it was not in my power to relieve them from any liability incurred by taking up arms against the United States, end quote. What do I do with them? Well, McClellan's forces already had about 500 other people by this time, so they have almost 1,000 people that are in military custody in Western Virginia. And he's asking Washington, okay, what do I do with them? I've got them. What do I do with them? Obviously, it would be impractical to treat them under federal criminal law. For one thing, there probably wasn't a U.S. District Court for the Western District of Virginia at this time. The judge had joined the Confederacy. You couldn't try 1,000 people in a reasonable period of time. So after consultation with the cabinet, the cabinet instructs General Scott to telegraph back to that to treat, responds, yeah, that they should be treated as prisoners of war. And that simple phrase gave McClellan good guidance on how he should treat them. U.S. Army regulations had detailed instructions on how you handle enemy prisoners of war, didn't have any instructions on how you deal with traitorous civilians. Now, so that's the first crack in the Lincoln administration's facade that we're not going to grant any international rights to the enemy during this war. The first crack in the facade appears. But the administration wants to hold the line in two areas. First of all, they're not going to negotiate what's called an exchange cartel. At this time and up through the end of the 1800s, it was common to exchange prisoners of war while the war was still going on. And this would usually be governed by an agreement between the two sides, concluded between the military authorities of the two sides. Between the military, I apologize for the telephone there. Between the military authorities of the two sides and setting out the procedures on how prisoners would be exchanged periodically. Typically also they would have a table of equivalents. Say we've captured 100 of your private soldiers. You've only got 50 of ours, but you've got maybe a couple of our officers. So the table of equivalents would say just notionally, a captain would be worth 5 privates, a major worth 15, whatever. During the American Revolution, for a time, there was a proposed prisoner of exchange cartel that provided that a lieutenant general in either of the Revolutionary or the British Army could be exchanged for 1,200 private soldiers. By the War of 1812, the British eventually did not approve that for much the reason that the Lincoln administration was reluctant. They didn't really want to give any further legitimacy to what they viewed as rebels. But during the War of 1812, the United States and Britain, there was another exchange cartel concluded, though at that time, a general officer was declared to be worth 60 privates. It's an interesting development, either a reflection of the growth of ideas of equality in Western civilization or a serious reassessment of the military value of generals, whichever. But I digress. In any event, the North position, strongly enforced by Attorney General Bates, was we aren't going to negotiate that. That gives them too much recognition. The second area where the North wanted to hold the line was in the war at sea. Remember, back in April of 1861, Lincoln issued a blockade proclamation on the southern coast. This itself was problematic since blockade was an institution of international law, and just issuing such a proclamation arguably gave the Confederacy a certain international status, but that's neither here nor there. In that blockade proclamation, however, he also included a provision quoted in on the slide there that said that the Union would not treat Confederate privateers as prisoners, as legitimate combatants, would not treat them as prisoners of war. What's a privateer? Okay, up until again about the middle of the 1800s, you could actually make a lot of money during a war, not just by selling supplies to your government, by actually waging war.
And we got it. I got in. We got in with Paul's account. Yeah. Okay. All right. Thanks, Dan. Okay.
Yeah. Oh, hi, Carolyn. How you doing? Anyway, she's already heard this probably about 6 times. Anyway, but the idea was that governments at war would issue licenses to privately owned warships called privateers. These licenses were called letters of marque, actually referred to in the Article 1 of the Constitution. It gives the Congress the right to issue letters of marque. But anyway, And then these privately owned warships would sail the high seas and capture merchant vessels flying the flag of the enemy nation. When that happened, they would capture one of these vessels, put a prize crew aboard it, sail the vessel to a friendly port, and there an admiralty court would decide whether or not this was a lawful capture under international law. If the court decided it was a lawful capture, then the court would supervise the sale of the vessel and its cargo at auction, and the proceeds would be divided among the crew and owners of the privateer. Usually the government took a huge cut too. But anyway, that's what privateers were. Well, the Lincoln administration says, because the act declaring war on the Union, the April Act by the Confederate Congress, also authorized Jefferson Davis as president of the Confederacy to issue letters of marque to members of the Confederacy. And the Lincoln in reply says, no, we are not going to recognize those as lawful combatants. If we capture any of your privateer officers, they're going to be treated as pirates and tried under U.S. federal law. Under federal law at the time, the only punishment authorized for piracy was death by hanging. So that's where the Union, Lincoln wants to draw the line, no further recognition of Confederate legitimacy. But then again, about the same time as things are occurring over in Western Virginia, the Confederacy does in fact issue several letters of marque, one of them to the owners and crew of a privateer called the Jeff Davis. On July 6th of 1861, the privateer vessel Jeff Davis captures a northern merchant ship, a sailing vessel, a schooner named the Enchantress, out of Boston. The Jeff Davis, as is the custom, puts a prize crew under the command of a Lieutenant William Smith, and takes the crew of the Enchantress and takes it aboard the Jeff Davis, where they'll be held as prisoners of war. Well, they take all the crew except for one member. The ship's cook is an free African American from Boston named James Garrick. And Garrick hears Smith say, "No, keep him on the ship. We'll take him back to Charleston for the Admiralty Court." And Smith says, supposedly, quote, "He'll fetch $1,500 when we get to Charleston," unquote. They're gonna, even though this is a free man, they're gonna sell him as a slave when he gets back to Charleston. Well, they start the sailing back to their port of Charleston. But on July 22nd, I believe off Cape Hatteras, they are stopped by one of the early blockading vessels of the U.S. Navy, the USS Albatross. They're hailed, "Who are you? Where are you going?" At first, Lieutenant Smith tries to brazen it out. He pretends, "Oh, I'm the captain, the Boston captain of the schooner Enchantress out of Boston." I don't know how he makes his South Carolina accent sound like he's from Boston, but he gives it a try. James Garrick realizes this is probably his last chance to slave his freedom. He jumps overboard, begins swimming toward the Albatross, shouting, "They're Confederates, they're Rebs." And so the game is up. The Enchantress is recaptured by the Albatross. The Albatross then takes Lieutenant Smith and the other members of the privateer's crew back to its home port, the Naval Yard in Philadelphia. And Lieutenant Smith is tried in the U.S. District Court in Philadelphia for the crime of piracy. On October 22nd, he is convicted after a trial, convicted by a jury, and he is sentenced to hang. October 22nd. November 10th, President Jefferson Davis of the Confederacy hears about this, and he says, "No way." By this time, the first battle of Bull Run has occurred. The North loses. The Confederacy has a large number of Northern federal officers as prisoners. Davis they actually captured a congressman too. I forget who he was. Anyway, the Davis has all the captured officers brought together in Richmond, and he actually has the congressman administer this ritual. He has them draw lots, and the guy who gets the black dot is then declared a hostage for Lieutenant Smith. He's taken to the Virginia Penitentiary and placed in a cell on death row. And by flag of truce, Lincoln is notified, okay, if you hang Lieutenant Smith, then we will hang our hostage. Now, the hostage that was chosen by lot was Colonel Michael Corcoran of the Fighting 69th New York State Militia, famous Irish American unit. Michael Corcoran is a power in New York Democratic politics. And this is a time when Lincoln's trying to rally the country, the war Democrats around waging the war. The last thing he needs is for the Confederates to hang a prominent Democrat, because Lincoln insists on hanging a pirate, or hanging a privateer as a pirate. Even the judge who sentences Smith to death remarks he thought it was kind of strange that if you were captured on land, you're a prisoner of war, but if you're captured at sea, you're a pirate. But he says, I'll follow the law. Well, the Lincoln administration tries to negotiate a solution. Okay, well, we'll have a one-time exchange. We'll exchange Smith for Corcoran. Nope. Jeff says, no. You got to change your policy. You got to treat us as prisoners, all of us as prisoners of war. Goes back and forth. Well, long story short, by end of January 31st, 1862, the United States government capitulates entirely. By the way, there was another trial going on in the U.S. District Court for the Southern District of New York for a different set of privateers. All of the privateer crewmen are transferred from the custody of the U.S. Marshals to the military to be held as prisoners of war. And thereafter, as a practical matter, after January of 1862, the United States government is treating at least the military members of the Confederacy in accordance with the international laws of war. They start negotiating an exchange cartel. The negotiators are these two gentlemen, General Hill for the Confederacy, General Dix for the United States. They finally, on July 26th, sign a cartel for the exchange of prisoners of war. The cartel later breaks down over the refusal of the Confederacy to regard African-American soldiers as legitimate prisoners, but that's another story. So by January 1862, the United States is applying the law of war to the Confederate States of America. Lincoln then starts to think, oh, okay. The president reasons, if the international law of war applies to the Confederacy, can't the president use all means and methods of warfare that are legitimate in international law against the Confederates, even though we don't regard this as an international war? If that's going to be, if they want the benefits of the international law, they have to take the downside too. And if this is the basis of the Emancipation Proclamation that he issues initially September 1862. He specifically makes this clear in his famous Conkling letter in August of 1863, where a public letter where he replies to many critics of his, or to many different criticisms of his war policy. And specifically, he talks about the Emancipation Proclamation. He says, and I quote here, "You dislike the Emancipation Proclamation and perhaps would have retracted. You say it is unconstitutional. I think differently. I think the Constitution invests its commander-in-chief with the law of war in time of war. Civilized belligerents do all in their power to help themselves or hurt the enemy, except for a few things that are regarded as barbarous or cruel. Among the exceptions are massacres of vanquished foes and non-combatants, male and female. By this time, the U.S. Supreme Court has also issued an opinion in earlier 1863 in what's called the prize cases. And the court holds that in suppressing the rebellion, the president has the constitutional authority to use any method of war authorized by international law of war. So Lincoln has strong legal authority for his assertion that he can issue the Emancipation Proclamation under the international law of war. We tend to think of the Emancipation Proclamation as this unique event, unique to American history. It is not. Lincoln's Emancipation Proclamation was the last great military emancipation proclamation, not the first. Emancipation of enemy slaves was very common practice in the colonial wars in the Western Hemisphere in the 1600s and 1700s and through the early 1800s. The earliest Emancipation Proclamation I've found was issued by the Spanish back in 1688. Again, some background. Spain claimed that the northern border of its colony of Florida extended all the way up to the southern border of what today is North Carolina. So when the British in the late 1600s founded the town of Charleston, which would become South Carolina, they regarded this as an invasion. They didn't declare war, but they did issue the Spanish governor in St. Augustine, the governor of Spanish Florida, issued a decree. Any enslaved person who could make it all the way down to St. Augustine to make it to the custody of the king's forces, we would be regarded as free by the Spanish government. And eventually, like I say, within about 10 years later, he communicates this back to Madrid. Naturally, the Spanish Empire is extremely bureaucratic. And in 1697, the King of Spain actually issues his own proclamation endorsing this decision of his governor in St. Augustine. So the King of Spain, 1697, Emancipation Proclamation was the earliest one I could find. Back in later on, so many African Americans fled to Spanish Florida that by 1738, the governor at that time, the Spanish governor, brought them all together and established a little colony at a place called Fort Mose, M-O-S-E, north of St. Augustine. Basically, the male members were regarded as a Spanish militia to defend St. Augustine from invasion by the British later on. Fort Mose was in a swamp. The location is probably underwater by this time. What you see on the slide here is the state of Florida's historical marker on the location of Fort Mose, established by freed slaves. Well, to make a long story short, Spain continues to issue emancipation proclamations throughout colonial wars in the Western Hemisphere in the 1790s, in the Caribbean, and the Napoleonic and French Revolutionary Wars. In Latin America, when the Latin American colonies in the 1820s rebel against Spain and fight for their independence. Again, the Spanish crown offers freedom to any slave of the rebels. In response, the liberator, Simon Bolivar, issues his own Emancipation Proclamation, saying that his forces will guarantee the freedom of any slave of people who back the royal forces. England, famously during the American Revolution and later in the War of 1812, offered freedom to American slaves who could reach British forces. France issued an Emancipation Proclamation in the 1790s, in the war in what today is Haiti. And in fact, the United States itself, even though a lot of the United States recognized slavery, actually invoked the law of war to free slaves itself in a rather unknown episode. involving the so-called Seminole Wars in the 1840s. The Second Seminole War is known as the graveyard of American military reputations. It went on for 10 years. The Seminole Indians, most of whom were well, I think the word Seminole in Cherokee may mean something like refugee. Anyway, they were Creek or Cherokee who had fled to Florida, to Spanish Florida, then originally Spanish Florida, and established their own structures, their own settlements there. Some of the enslaved Americans also fled to Florida and joined the Seminoles. They became fully acculturated as members of Seminole Indian nations. The Seminoles were masters of guerrilla warfare. Very difficult to defeat them militarily. Finally, one American general had the bright idea, and he took a couple of the Seminole leaders that had been captured. He took them out to the Indian Territory, sat them down, and says, "Look, this is where you'll go if you surrender to us." And they said, "Well, that's not too bad. No alligators around or anything." Yeah. "Oh, okay, maybe we can do this." So he sends them back to take the word back that, hey, we're going to a place that won't be too bad if we surrender to the American army. Except, of course, those Seminoles who are of African descent. They say, "No way. If we surrender, we're going to go back into slavery. We're not going to with the Indian Territory." So General Jessup then says, "Okay, you'll go to the Indian. We're not going to surrender you to your masters." And in fact, when the first steamboat going along the coast up to New Orleans and then is unloaded, preparatory to taking them further up the Mississippi and the Red River to the Indian Territory, sure enough, representatives of slave owners show up and say, "Oh yeah, hey, that guy, he's a fugitive. I own him. I own that woman." And the Army's response is, "No, these are prisoners of war. Prisoners of war. They've surrendered under the laws of war on condition that they be granted freedom, and you're not going to get them." And that's what happens. There were so-called Black Seminoles up in Oklahoma. I think many of them are still there. Their descendants are still there. So it wasn't, given the sensitivity of slavery in the United States in the 1840s and 50s, this didn't get a lot of publicity. But even the United States government, when required by necessity, was invoking the law of war to grant freedom to its enemies. So it's a well accepted then custom that offering freedom to your enemies is a legitimate tool of war in international armed conflicts, and even sometimes in internal armed conflicts, as in the case of the Seminole War. What this means? This means that if the Confederate States of America really were what they claimed to be, an independent sovereign nation, they had no legal basis to object to the Emancipation Proclamation at all. This was a common thing to be done. In fact, my understanding is that at one point in the Georgia Secession Convention, that one of the Alexander Stephens, who later became the vice president of the Confederacy, actually initially argued against secession to protect slavery. He says, "Look, if we secede, there'll be a war, and Lincoln will issue an Emancipation Proclamation. The war will destroy slavery." Of course, the secessionists were not convinced by that, and Stephens' prediction proved true. This is why the Jefferson Davis had to shift the focus in his objection. He said, "Oh, you're not really freeing people. You're trying to incite, this is a terrorist document. You're trying to incite a massive rebellion where enslaved people will sneak up in the middle of the night and cut the throats of the families of their masters, women and children. So this is just a terrorist operation." document. The Times of London actually bought this for a time, but of course, as things turned out, the so-called terrorist rebellion never occurred, and eventually the Emancipation Proclamation led to European support for the Lincoln administration. But I'd like to then end up by focusing on how Lincoln's proclamation actually was very radical. It was different from the traditional Emancipation proclamations. All the earlier proclamations had indicated that slaves would be enslaved people belonging to the enemy would be free as soon as they came under the control of the enemy army. They're freed if they can make it to the enemy military lines. And this is based on, includes General Butler's contraband theory of that early on in the war. And this is based on the international law of property in wartime. In land warfare, captured enemy property, legal title to captured enemy property passes only upon actual capture, only upon when the property is actually reduced to the control of the capturing army or a navy. And so the traditional the traditional Emancipation proclamations are based on the theory that slaves are property. Lincoln's proclamation goes beyond that. He said, it doesn't matter if you make it to our lines or not. We recognize you as free from the January 1st, 1863. We regard you as free. Think about the moral implications of that. From the point of view of the executive branch of the United States, after January 1st, 1863, the South is illegally detaining free people as slaves. That was the official position after the Emancipation Proclamation, that all those people down there were free and the South had no right to keep them. Lincoln had initially, of course, long stressed the humanity of slaves, and going back to his debates with Douglas earlier. There was, like I say, a specific international legal authority for this doctrine. Emmerich de Vattel, who was a Swiss jurist who wrote in the 1700s, Vattel was extremely influential in the United States before the first half of the 19th century. One legal history indicates that Vattel's work was the most commonly cited source whenever a question of international law arose in federal court. They would usually go to Vattel. Vattel was invoked in debates in George Washington's cabinet back when they're deciding whether to be neutral in the Revolutionary Wars of France. So Vattel is very highly regarded in the United States in this period. And Vattel at one point says that it is permissible in war for a nation at war to free an oppressed people for two reasons. First of all, to gain allies, and secondly, as an act of justice. That's the title of my book, comes from that phrase, act of justice. And the final Emancipation Proclamation that Lincoln signs on January 1st, 1863, actually uses this phrase. It says, I'm doing this as a matter of military necessity and as an act of justice. Direct quotation from Vattel. Later, Simon P. Chase, the Secretary of the Treasury, noted abolitionist, later claimed credit for introducing this phrase to Lincoln. Actually, Senator Sumner had directly in debates in the Senate had earlier used the phrase and directly quoting from Vattel, and Chase got it from Sumner, though he would never admit that. Both men having immense egos. But in any event, that's where I'd like to end up. Lincoln's Emancipation Proclamation is not only not unprecedented, it goes beyond the precedents to recognize that enslaved people are people. They're not just property, and the law, international law, does not regard them just as property. So with that, I'll end. And have I gone over? I don't.
No,
No, you're perfect. And
Thank you. Any questions? Oh, glad to help.
yeah, people can put questions in the chat if you wish.
I have
Also
a,
unmute yourselves. I can read them from the chat if there's anything in chat.
okay, let me try to end the show here. Yeah, I'll end that. See, I'll make this bigger.
there you are.
There it goes. Okay, screen sharing
I
starts.
have
There we
one
go.
question for you,
Sure.
and that is regarding in Missouri,
Yeah.
when oh gosh, the name of the fellow just flew out of my head.
Fremont,
Pardon?
Fremont.
Thank you. John Fremont had an Emancipation Proclamation of his own, which
Yeah.
Lincoln then thoroughly rejected and fired
Right.
John Fremont. Do you have any comments on that?
Yeah, what had happened was that Fremont was the commander of the Department of the West that was west of the Mississippi River. His decree, basically, he issued an executive or a military proclamation saying that anyone in any slaves held by people who had taken up arms against the United States would be free. At this particular point, the state of Kentucky was neutral in the war, or asserted it was neutral. The governor of the state was pro-secession, the legislature was pro-union, and so the compromise was, well, we'll be neutral. Was absurd, but that was what they were trying to do. So both the Union and the Confederacy were trying to avoid pushing Kentucky over the edge into the other side. The commander of the United States forces that in the area was General Robert Anderson. He was the guy who had defended Fort Sumter, but he was a Kentuckian by birth. And his headquarters was in Cincinnati. He didn't actually have any forces in Kentucky, again, to try to preserve Kentucky's neutrality, supposedly. He and Lincoln's old friend, the Kentuckian Joshua Speed, both warned Lincoln, hey, this decree of Fremont is going down very badly in white Kentucky public opinion. And it'll quite likely push Kentucky over the edge to secede. So that's the real context for Lincoln saying, whoa, back off. What he told Fremont to do was, okay, just conform this to the First Confiscation Act, which basically enacted into statute law the Ben Butler's contraband theory. That is, if slaves who actually work in support of Confederate military operations would be freed. And Fremont refused to do that. And so Lincoln said, okay, I'll do it myself. And he just did it. But that's the story behind that, as I understand it.
I have a question.
Yeah.
How did the 4 slave states that remained in the Union view and react to the Emancipation Proclamation?
Very badly. Well, Kentucky did anyway. There was a division. And I don't know if you're looking now at James Oakes's Crooked Path to Abolition. I have a lot of problem with chapter 5 of that book, but Oakes argues that actually the Emancipation Proclamation, one of its main purposes was to pressure the slave states to abolish slavery themselves. And it worked in the case of Maryland and Missouri. They, in 1864, each adopted a constitution that abolished slavery on their own before the 13th Amendment. But the remark is often made that Kentucky joined the Confederacy after Appomattox. If you go to Kentucky today, or at least among the white population, yeah, they remember their valiant brothers who fought for the Confederacy. Actually, more Kentuckians fought for the Union than ever joined the Confederate Army. But yeah, it did produce a bad reaction in Kentucky. But by that time, the military lines were down around Nashville. So the idea of Kentucky with seceding at that point was just a non-starter.
Thank you.
Anything else? Okay. Well,
Burrus, we can't thank you enough. That was very thought provoking. I guess one of the comments I would have, I know enough to be dangerous about the whole thing.
Huh.
And a lot of our members are very well steeped in Civil War history. I think one of the things that just fascinates me is the whole area of logistics. But beyond that, this whole area of politics and the politics that were going on, in front and behind the scenes. There's years worth of research on that, obviously still to be done or to be had, but this has been very, very insightful. And on behalf of our membership, thank you. Hopefully we can call on you again at some point to make another presentation for us. So any other questions? I think Carolyn got up and left again.
she's heard, I said she's heard this about 6 times. So when she was
Fair
in the
enough.
Washington area. So
I see Paul's head at least. So anyway, on behalf of our group, thank you so very much. We do appreciate
my
it.
book, I'd say, was published in 2007. I think it's still in print. You can get it on Amazon.
Okay.
Yeah, get more if you want. I've got a few copies too. I might be able to give you a better price than they do.
Okay.
But
We do.
contact me by email. Anyway, yeah, I've got quite a few other talks that I've given, including the one on Mosby and on Mosby and Urban Melville.
Oh, that'd be great.
Talk called, I was talking about that earlier, talk about gray ghost and white whale.
Okay.
Where Melville visited a relative of his in the town of Vienna, Virginia, where I live now, and later wrote a semi-epic poem about the Confederate guerrilla John Singleton Mosby, and he is analogized to the white whale in Moby Dick, and the role of Captain Quigg is taken by a Union cavalry colonel who goes out to try to capture him, and of course he gets killed in an ambush. But Gray Ghost and White Whale, and I have one about Lincoln's. Most recently, what about Lincoln's amnesty? Where he, about Lincoln is famous for being a very merciful president. And look at, well, when didn't he grant amnesty? What kind of reasons would he give? And I have about a half a dozen examples, and I think come to a conclusion that he would do this where he would deny amnesty where it was important for an important political reason.
Right.
And some good examples, I think.
Well, you can count on hearing from us again.
All righty. Sure.
All right. Thank you so much.
Bye-bye.
Bye-bye.
Thank you.
Bye-bye, Karen.